custody hearing can feel overwhelming. The stakes are high and the outcome shapes your child's life for years to come. Success comes down to one thing: being ready. I'm Jeff Hughes, lead attorney at Sterling Lawyers, and we have helped thousands of Illinois parents through the custody process, and I want to make sure that you show up prepared, not blindsided. In this video, I will break down the exact steps that you need to walk through when preparing for your Illinois custody hearing. From paperwork to what to wear to how to speak in front of a judge, and these steps will help you feel focused, not frantic. Step number one, get your filings right. Timing is everything. So to begin, make sure that the court has all of the required paperwork. You typically start with a petition for allocation of parental responsibilities. This is found under 750 ILCS 5/602.5 and the 602.7. The other parent must also be properly served and given the chance to respond. And you'll need to file a proposed parenting plan within 120 days of service. Now, once all of that is complete, the court process can begin. A hearing called an initial case management conference will be held usually within 60 days, and a full case management conference must follow 30 days after that. Temporary hearings, mediation referrals, and required parenting education may also follow. So why does this matter? Well, if you miss any of these deadlines, the court can move forward without your input. Step number two, understand what the judge is actually going to rule on. Many parents confuse decision-making with parenting time. And here's the difference. Decision-making responsibilities cover big decisions like education, healthcare, religion, and extracurricular activities. On the other side, parenting time covers where the child lives and with whom. Illinois courts may order joint or sole allocation of decision-making responsibilities, shared, primary, or other customized parenting time schedules. That is not necessarily what is fair to each parent. That is not a part of the judge's consideration. Step three, collect documentation so that you can tell your story. Your word alone will not win cases, so start gathering parenting time logs, school and health records, texts or emails showing involvement or concerns about the other parent, pick up and drop off records, any documentation that reflects daily routines and responsibilities involving your child. I recall once Maria, she used a shared online calendar to document every activity, meal, and appointment. And when she was later challenged about her involvement, she had timestamped proof of her daily presence, and that moved the judge in her favor. Judges look for patterns, not focused on isolated events. Step number four, go into mediation ready to work. Illinois law requires mediation in most custody cases, unless there's domestic abuse or another really good reason to skip it. So do not walk in unprepared. Be clear about what you want. Know your child's needs and routine. Stay flexible but focused. And stay calm because your behavior will be observed and remembered. Mediation can completely change the outcome in a custody case, and it's often because one side showed up ready to negotiate while the other side came in cold. Step number five, complete your parenting education. It counts. Under Illinois Supreme Court Rule number 924, parents must complete a mandatory parenting education class. And it usually lasts 4 hours, and you must complete it within 60 days of the initial case management conference. Judges review attendance and they review attitudes. It's a sign of how serious you are about co-parenting. Failing to complete this course can lead to sanctions or worse, delay your case. Step number six, present yourself with confidence and composure. When it's time for court, dress professionally, but keep it professional. Arrive early, speak calmly, stick to the facts, and most importantly, focus on your child, not on your grievances with your ex. Practice your answers with your attorney or with someone else prior to court. You can probably speculate on the most common questions that you will be asked. And your goal is clarity, not persuasion. A mother we once represented, she practiced her responses so well that the judge actually noted her clarity and concern for the child's welfare in his final ruling. Step number seven, understand who is evaluating who. So at your Illinois custody hearing, The judge is the one who makes the final decisions. Attorneys are for both parents. The guardian ad litem, also known as a GAL, that person is appointed under 750 ILCS 5/506. This is the person who investigates and makes important recommendations to the judge. And there may also be expert witnesses, such as psychologists, evaluators, or social workers in complex cases. They are always watching how you behave and not just what you say. Step number 8, know how the ruling will impact your future. The court's decision will determine child support, and that is based on parenting time and income. Relocation rights, you'll need court approval to move with your child, and legal authority over major decisions. And if safety is a concern, you can request a temporary order or other protective measures during your case. Many parents walk into a custody hearing fully prepared, thinking that they have done everything right, only to realize too late that Illinois divorce laws can still put their parental rights at risk, and sometimes before they even step foot into court. So in this next video, we will show you exactly how those risks play out and what you need to do now to protect your relationship with your child.